In this lesson, we're going to be talking about rules of evidence. So, what do I mean when I say rules of evidence? Well, rules of evidence are used to decide whether, when, how, and why facts and proof can be used as part of a legal proceeding. These rules of evidence have been created over centuries, and they're used to ensure that evidence is good and appropriate. So not only is it accurate, but is it something that makes sense to be part of these legal proceedings? Will it help to get to the truth or to try the facts in the case of this legal proceeding they are being asked to be a part of? The rules of evidence may vary based on the legal proceeding that's underway, if it's a civil case or a criminal trial, or maybe it's a family court situation. The rules of evidence may vary based on those particular sets of circumstances. In the case of the United States, we have federal rules of evidence. They were enacted in 1975. There have been subsequent amendments to the federal rules of evidence over time. But essentially, the rules of evidence have been in place as we know them since 1975. And what the federal rules of evidence do is govern the initial presentation of evidence. Now, they're federal rules of evidence, which means that the states have some ability to enact the federal rules of evidence as they are, or have their own rules of evidence, which may be modifications of the federal rules of evidence. So the states may have their own sets of rules for how evidence is presented in a legal proceeding. As always, it's good to know the jurisdiction that you're in and what particular laws apply to you in that jurisdiction. The way the rules are structured is there are 67 individual rules, and those are broken down into 11 articles. For example, expert testimony is handled as part of the federal rules of evidence, as is hearsay, handling of witnesses, and the contents of writings, recordings, and photographs, which is where a lot of the material that we would be dealing with in a computer forensics case would come in. So computer forensics would fall primarily under writings, recordings, and photographs, and that's one of the articles in the federal rules of evidence. Now, as I said, different jurisdictions have different rules, and Canada, of course, is its own completely unique jurisdiction, being a separate country. Now, they have the Canada Evidence Act, which was first passed in 1893, nearly 100 years before the United States enacted their federal rules of evidence. In Canada, though, the Canada Evidence Act only applies to trials held under federal law, and there are some exemptions to that, but primarily the Evidence Act only applies to trials that are held under federal law. So why do we have the federal rules of evidence? Well, they help determine authenticity of evidence. So you are presenting the best evidence possible, and you're not presenting something that's inaccurate or incomplete or has been manipulated in some way to not be authentic. So they're there to help determine authenticity. They're also there to help identify evidence. So what is the evidence and how does it relate to the case? So is it relevant? The federal rules of evidence determine relevance. They also help determine opinion versus fact, and this is more related to a case where you might become an expert witness. The rules of evidence are there to help determine which of your statements are opinions and which are factual in basis and foundation. So that's what the federal rules of evidence are there to do, is to help determine the authenticity, make sure that we understand what the evidence is and whether it's relevant, and also help determine what's opinion and what's fact. Now, how do these rules of evidence apply to us as computer forensic investigators? How do they relate to computers specifically? Well, there's guidance around authentic evidence, and the rules ensure that evidence collected is not deemed hearsay. Hearsay would be indirect evidence and not original, and there's always a risk when we're dealing with digital artifacts like files and chunks of memory or whatever we're looking at, anything that's been digital, there's a risk that it has been altered in some way that may not be able to be determined or can't be determined, in which case it puts that evidence at risk because it may be considered hearsay or inauthentic in that case. So as computer forensic investigators, our job is to make sure that we have got the most authentic and best evidence that we can get, and that it has not been tampered with in any way, and that we can prove and demonstrate that. And again, sometimes that's difficult to do because of the digital nature of it and the ease of manipulation or modification. So, in conclusion, you want to make sure that you're following the rules of evidence to help ensure admissibility. If you can't admit a piece of data, it doesn't help the legal proceeding that that evidence is meant to be a part of. Procedures for handling and acquiring evidence are critical, and following those procedures and guidelines is critical to make sure, again, that the evidence that is acquired is admissible in a legal proceeding. And again, we're always looking for the best evidence to present, and that means the most original, the most authentic, the most accurate evidence. So that's what we're looking for when we are looking for evidence. And again, the federal rules of evidence help us to know what all of these criteria are for presenting evidence in a legal proceeding.